the next topic. So maybe now you could deep dive into the merger control, because I think there some good changes have happened on the merger side. So
Exactly.
competition, merger. So so as competition law, everybody understands, is divided into three sections. One is the combinations, mergers, etc. The other is the abuse of dominant position, and the third is anti-competitive agreements. And then, of course, there are other miscellaneous provisions, etc. So merger being one of the very important one which applies to corporates. So, Mr. Sharma, what changes have been done in the combinations, mergers, procedurally, and otherwise in the thresholds, timeline, etc.? It will be interesting to note that. Yeah.
Thank you. So let me start with this merger control provision. Let me first add a caveat here. Let us all remember that mergers and acquisitions are not prohibited, but only regulated under the law. Unlike the anti-competitive agreement, which are actually prohibited, whether this competitive agreement between the direct competitors or between vertical also, or the abuse of dominance, this mergers and is not prohibited. So why it is regulated even? Because there is a concept of single firm dominance. I'm just giving you a little bit of economics behind it so that people understand why do they regulate, because it was seen as a handicap for the businesses. Because there was a long, I remember when I was in the CCI, there was a long protest, very strong protest even for the inclusion of this provision in the act. And why should you regulate mergers and acquisitions? They are the business, how the business grow. Organic growth of business takes place through the mergers and acquisitions. So why should CCI even enter in this space? The point is, the problem happens is that when there is a possibility of a single firm dominating the whole scene in the market, so that actually that's the requirement where the commission has to step in. And the theory of harm is known as unilateral effect. So you should not monopolize the market to raise prices above competitive levels. That is the basic fundamental principle. So if there is suppose Vodafone and Idea, Vodafone and Airtel, and now there is the third Geo. I'm just giving you an example. So there is a triopoly. So there's sufficient competition into the market. People have a choice. So people should have the choice always. That is the purpose of this act. So mergers and acquisition are regulated because CCI will always ensure that there is some competition in the market remains. So if there is suppose a direct merger between two cement companies in the same area, they will see that the divestment takes place. So the third party has to be brought in to buy. Divestment is also ordered. So this is the basically understanding of the subject. And then now let me come to this slide basically sums up. This slide sums up the existing law, that is merger, amalgamation, acquisition of shares, and there are high threshold limits. This is the existing law as I just summed up. And there's a mandatory regime. So there is a suspensory regime in India where after you file till the CCI approves, you cannot take any step. You just cannot take any step. The whole thing comes to a standstill. It's called a standstill obligation. And then the commission was given 210 days to decide without, or this was deemed as approved. And or suo motu action can also be taken if you don't file the notice to the CCI in such cases. And this is an ex ante regulation. That is very important, because why it is ex ante? Because if the merger has taken place and then you cannot unscramble the omelette as it is said. So basically, this is ex ante is the only provision in the act which is ex ante. Otherwise, the other provisions are all ex post. So after the effect has taken place, the CCI will intervene. In this case, they have to do an advance checkup. It's basically an advance assessment of what will happen in the market if we allow this merger to take place. Not only merger, an acquisition. So if the large player acquires a small player, what will happen? The choice will go whether the consumer will be happy or not. And it's not only the consumer welfare standard. The competition per se should not be reduced. Please remember one thing, that the competition law, of course, the ultimate objective is of the consumer welfare, but consumer welfare, in my opinion, is not the only object. The total welfare is the object. That means welfare not only of the consumer, but also of the producer also. So both have to be equally happy. So with that thing in mind, these regulations have been made. Now I'll just come to straight away to the changes which have happened. And these are the existing thresholds. You can see they are the highest in the world. 2,000 crore of assets and 5,600 crores of turnover for a single company, blah, blah. I'm not repeating. You can see there is a de minimis exemption that is extended for 10 years to 27 March 2027. That means if the target size is smaller, 350 crore of assets, 1,000 crore of turnover need not file. So those exemptions have already been given to the industry by the government. But there is another interesting feature of this definition of the group, for which the extension was granted, but it actually has lapsed in 2021. It has not been extended. That's an important thing. That's why I've highlighted in yellow. So the definition of group earlier was in the act was 26%, but they extended to 50% voting rights. That will be covered as a group, but then it has not been extended for 21. But now it has been codified in the law and brought back as 26%. So now I'll deal with the specific changes which have happened. So a new threshold, you see, of deal value threshold has been introduced. Earlier, we had a 12th threshold of asset and turnover. So either you have assets 2,000 crores or you have turnover of 2,000 crores. So now what they have done, a deal value threshold. That means if you are, what is the size of your transaction, how much business you are taking over. So this threshold also has been kept synonymous with the asset based, that is 2,000 crores. So it is not arbitrarily, this figure has not been arbitrarily picked up according to me. It has some semblance of a reason, because the minimum criteria for combination was 2,000 crore of assets. So now they say if you have a deal which exceeds only 2,000 crore, then only you need to be considered as a combination. And but there is a proviso here. The proviso is a substantial business operation. That means you should have local nexus in India. So if Google is acquiring some company, right, the deal size is just 500 crore, it need not notify. Google may have whatever turnover. Simple example. But if the deal size is more than 2,000 crore, because that will be written in the share subscription agreement, etc. So then it has to notify, provided it should be presence in India. So the local nexus is an additional threshold, additional caveat provided, that was very well thought of and very well discussed in the competition law review committee. And this substantial business operation, what it will actually be notified by the government by rules. No, sorry, by the regulation by the CCI under section 64 of the Act. So substantial business operation in India will be, for which regulations will come, but I can tell you that it is something to do with local nexus, how much presence you have. And this is just imagination, whether it is e-commerce, how much they'll take up. So it depends, but this notification has to come. Now, the second thing is definition of control. This is equally important, the dilution of center of control from decisive influence to material influence. Now, what does it mean? See, the ability of control, if you see the definition of what is a combination, it is the ability, a combination takes place when you either acquire voting rights, assets, shares, or control. So all others are specific figures, how much shares you've acquired, how much assets you've acquired, they're all quantifiable. But the control is something which is not quantifiable. So control has the most controversial, subject in the competition law for this topic is control. What is a control? So control can have, whether you are in a control, whether you actually acquire more than 50%, then apparently yes, shares, that there is no problem. But what if their control is only minority? Suppose you acquire only 25% of a company, or only 20% of a company, or even my minority shareholding. You have 10% of minority shareholding. Still, will you be considered as having a control? Would you be considered as acquiring a control? Now, what the CCI earlier was, the view of CCI earlier was that initially they were going by decisive influence. Only if you are acquiring what is known as a a position in which you can decide.
I think some internet connection issue again at Mr. Sharma's end. Let's hold for some.
Connected.
Yeah.
Am I audible?
Mr. Sharma, you were disconnected in between, so maybe dilution
again?
Definition of control you can again start with. Yeah.
Am I back again?
Yeah, you are back again.
Okay, good.
So dilution of definition of control, maybe you were speaking, so you can start with that.
So this actually codifies, this amendment actually codifies the existing decisional practice, of which has evolved over a period of 11 years of the regulation of companies. So initially it was decisive influence, then it was slowly changed to material influence. And this actually, material influence has also been debated. What is material influence? So do you mean that if I appoint a board of director in a company I'm acquiring, or I'm an investment advisor, I'm a PE fund, for example, I appoint an observer into a company just to observe will it be considered as material influence? Yes or no? It's gray area. You don't know. So this is actually, according to me, a very debatable, still not a very, very progressive step. Rather, it's a step backward. That's why if anybody happened to see my blog, which I wrote recently in my blog, the India meant the competition law, this I took it as a retrogative step, according to me, that it's a very vague test, because substantive, it will lead to substantive gun jumping. I'm a venture, I'm a private equity investor, I'm a PE investor, and I keep on taking shares in the companies. But will it mean that if I put an observer or anything which I do, which has a presence in the board, which will be considered as a as kind of a control or material influence? So material influence actually is a vague test, but the government, for whatever reasons, because there was a debate in the CLRC which said that material influence and disinfluence you have to decide. But ultimately, I think the standing committee also went in favor of the material influence test. So this will actually lead, according to me, cases of gun jumping. Gun jumping means that you violate the law by not by choice but by ignorance of law. It negates earlier jurisprudence where mere acquisition of affirmative was not considered as equal to acquisition of a control, and list of such rights leading to joint control or strategic commercial operations were provided. So basically, when the control shifts from sole control to a joint control, that is the point. That's where the material influence actually is tested. So according to me, CCI can, can do anything. I mean, in this case, it's a very, very vague test, which actually needs to be little debated. Then of course, turnover and value of transaction have been defined for this. Now I come to the other changes, the removal of mandatory 30 days limit. Now these are the changes which one must note. So there was a 30 days trigger initially in the law, which was that you have to notify the transaction within 30 days if it is a combination. That means if your transaction is meeting the thresholds, if your total both parties assets and turnover are exceeding the limit which are given into the section 5, if it is a combination, then you have to notify that combination within 30 days of the signing of a binding document or any other document which was defined. Now this has been removed. Actually, it was removed much earlier in 2017 by notification, but now it has been codified. It's not that it has been done now. It was already there. It was already been done, but now it has been practiced. It has been brought into the law, so it has been formally codified. 30 days limit has been removed. And then the important thing is other documents have been actually explained. That is voting rights and including hostile takeovers or making public offer also as per the SEBI regulations. So this option, this is a very important change of open offer. If you make an open offer, and if you notify to the other regulator, and if you don't notify to the commission, there were cases where they were considered as gun jumping cases. Penalties were imposed because public offer was made, and the SEBI was informed under the takeover code, but CCI was not informed. They were informed after the SEBI had been informed. So the commission considered them as a kind of a negative, as a kind of a gun jumping, and penalties were imposed. So this has been actually thankfully removed. So this now this is the biggest change which has happened. So waiver of obligation of, I think this comes here. This comes in the next slide. I'm sorry. Waiver of standstill obligation for open market purchases. So existing standstill obligation in case of open offer and acquisition of convertible shared securities is waived or provided. And notice for such acquisition is filed within the statutory time limit to specified by the regulation. So this is the caveat they have put. So it's not that they have totally done away with it. They are going to come out with regulation which will specify the time limit within which you have to with which you have to give the notice to the CCI. And also within that period, why the CCI has approved, the acquirer should not exercise any ownership or beneficial rights or interest into such transaction. They should not do it. So the new section 6A has been inserted now under the Act.
Mr. Sharma, for certain non-technical folks, including me, if you could clarify what is standstill obligations and slightly make it easier to understand.
No, as I said in the beginning, standstill means that when there is a combination, if a transaction qualifies as a combination, that means you have thresholds meeting, right? So you cannot consume that transaction. You cannot proceed with the transaction. You have to get it cleared with the CCI.
Right.
Until the CCI clears it, your transaction will remain suspended. It's a mandatory suspension regime, we call it. That is standstill obligation. And if you don't
seeking the approval and you cannot go ahead without the approval, that's what you're calling a standstill.
Exactly. And see, there are big ticket size, big mergers, big size. You can understand 6,000 crore plus, 2,000 crore plus. We are talking, and they are big companies, and there the purchase the joint, and including the joint venture also, for example, they also have to be notified. So these big ticket transactions, they require prior approval because, as I said, they affect competition.
Yeah.
And their appreciable interest in competition is possible.
On the earlier slide also, I was noticing when the 30 days time limit to report this thing merger has been done away with. So earlier the board of directors used to file a resolution or any other document was to sign, and within 30 days one had to approach CCI for approvals. But now that
if you don't, you were penalized. There were various cases where they were penalized. Huge penalties were issued.
Right. So now that 30 days has been removed and it says before consummation of your merger or other combination, you need to approach CCI and CCI will then revert within 150 days as opposed to earlier 210 days. So
no. 150 days is the maximum time with which they have to approve it. Otherwise, it will be deemed to be approved.
Otherwise, it will be deemed to be approved. Earlier, that limit was 210 days, right?
10 days. Now the limit has been reduced to 150 days.
So what is the reason for removal of this 30-day reporting? I mean, now after board resolution, I can even approach after 3 months, 4 months. So what is the reason for removing 30-day timeline?
See, this is just, as I said, to give ease to the business, to the industry, just to give ease of doing business. The concept is making it business friendly. Unnecessary penalties were imposed on large companies, including Tata. Big companies were penalized for 1%. Imagine 1% of turnover. It's a huge penalty.
Right.
So why should they? Because this is a technical requirement. Because you will in any case take 210 days.
Yeah.
Why you insist on 30 days filing when you're yourself going to take 210 days? So let me file after, say, 35th day. What is the problem? Heaven is not going to fall. So the industry actually lobbied with the government, the Ministry of Corporate Affairs, and that's why this change was brought in 2017. As I said, it's not a new change.
Yeah, but it's been codified now. Right.
Now it has been codified. That is what is very important. So, and similarly, the open market purchase also. You see, there were various Ultratech Limited. There was some various cases. I don't have to give the case of where even GE Alstom, where the open offer was made, public announcements were made, but CCI was not informed. So just because it was not done, the penalty were imposed.
Right.
And these cases went up to the Supreme Court. It was actually unnecessary litigation, which has now been removed, thankfully. And this open market purchase is a very good, system. Though they have kept the control over them by providing regular time within which they have to inform the commission.
For open market purchase, what is the time limit now?
No, they will come out with regulation. I said.
Achha.
It's written, they have to come out with regulation and prescribe the statutory time limits.
Okay.
But within that period, they don't have to exercise any control. So I'll give you an example. There was an example of a company I will not name, which gave a loan to a company which was dying. It's almost, and they wanted to acquire that company. I mean, I will not name because it's very well known. And this some few crores, hundreds of crores loan was given so that the store can run. Now, because they gave the loan to make the company viable, CCI considered it as and then they filed a notice in the CCI that we are taking out this company. Pinani, I don't have to name. So what happened was the CCI started 43A proceedings against the company, large company. And why have you given loan? Though in the investment agreement was very clearly written that this is a refundable loan subject to the approval of CCI. Even then, the CCI considered as a gun jumping. So I'm saying there were very controversial decisions. This time is not permitted me. I'm not going to go into those individual cases, but this was a very, very big handicap for the industry. They were very, very troubled. What is this happening? No reason, no. Because law was like this. So the CCI had to follow it. But now, thankfully, the government has changed it. And that's why this has been made more business friendly. And then important thing, green channel. Let me proceed to this. What is green channel cases that you people already know? So green channel actually is was also started after 2018, immediately in 2019 by regulations. CCI came out with a regulation that where there is no horizontal overlap, there's no vertical overlap, and there's no complementarity also between the two parties. Then they need not wait, and it is deemed to be automatically approved after filing. They have to file. Filing has to be done. If there is a transition between two large companies, which has no overlap, understand? But still you have to file it. But you don't have to wait for the CCI's approval. This was deemed to be automatically approved. So this was going on. Many filings have been done by the CCI. In fact, many green channel have been filed, hundreds of them. But now it has been codified properly by adding section 6.4. A new section has been added.
So these rules would be yet to come, right? For green channel and other things.
No, there's no rule requirement now. Now the law is there. Yeah, the rules have to prescribe criteria, as I said, already known to the industry, but they'll come up with formal rules. The rules are, as I said, no horizontal overlap, no vertical overlap, and no competition. Well, where there's no question of any competition issue coming at all, then why should it wait? It should be deemed to be approved. And then, of course, this section has been added. The next slide, as I said. Yeah. Now, but there is some caveats are also there. So the penalties have been increased for, if you see, making false or incomplete disclosure in statutory notices to be filed by the CCI. It has now been made 5 crores. While they have given benefit to on one side, the other side they have increased the penalty. And specific penalty for gun jumping also has been up to maximum 1% of turnover has been made, which is higher, for failure to give notice even under 6.2 or 6.4.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000 plus laws and 24,000 plus compliances. All in an integrated platform that is easy to use with automated alerts and risk management capabilities. Is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.